10 second, 5 second, start. The above excerpts indicate that the state enactment purports to set up a regulatory authority for the housing industry, save and except for this emphasis on the housing industry. The broad purpose of the state enactment coincides with RERA. Before we set out a comparative table of the corresponding provisions of WBHIRA and RERA, it is necessary to note at the outset that there is, in most of the substantive provisions, a complete overlap of the provisions contained in the two statutes. Evidently, the bill for the introduction of WB HIRA in the state legislature was prepared on the basis of the RERA as a drafting model. Hence, during the course of this judgment, the provisions of the state enactment which are at variance to those in the central enactment will be delineated separately. However, at this stage, a sampling of some of the crucial provisions would indicate that they are identical in their entirety. In the state of West Bengal's WB HIRA and RERA, which has been enacted by Parliament, it needs to be emphasized that the tabulated provisions of the state enactment are verbatim a reproduction of the central enactment in most instances, with minor differences between the provisions due to RERA being a central enactment and WB HIRA being a state enactment, but those are not relevant for our present discussion. Application of other laws and Barrett, the provisions of this act shall, in addition to and not to derogation of the provisions of any other law for the timing being in force. Section 83 corresponds to Section 88 of the RERA. However, there is a provision in WB HIRA corresponding to Section 89 of the RERA, according to which overriding effect has been given to the RERA, notwithstanding anything incoincident therewith contained in any other law for the time being in force. Further, the repealing provisions of the two enactments are distinct. Section 92 of the RERA has repealed the Maharashtra Act, while Section 86(1) of WB HIRA repeals the West Bengal 1993 Act. In the previous section, this judgment has dwelt on the substantial overlap between the provisions of RERA and the subsequently enacted WB HIRA. However, in this segment of the judgment, it would be necessary to visit the inconsistencies and deviations made in WB HIRA from the provisions of the RERA. The subject of both the central and the state enactments is covered by entries 6 and 7 of the concurrent list to the 7th schedule to the Constitution. RERA is a complete and exhaustive code which regulates the contractual relationship between a builder, promoter, and a buyer consumer in the real estate sector and provides remedial measures. Parliament has indicated an intent to occupy the whole field. RERA regulates the rights and obligations between promoters and buyers of real estate in addition to the provisions of the Indian Contract Act 1872. The enactment in ensure the actual transfer of property to the buyer furthers the objectives of the Transfer of Property Act 1882. It provides for the enforcement of contracts through remedial measures which are in addition to the remedies provided in the Consumer Protection Act 1986 and its successor legislation of 2019. RERA, in other words, is a special statute governing the real estate sector encompassing rights and obligations found in different central enactments, and WB HERA covers the identical field of regulating the contractual behavior of promoters and buyers in real estate projects. The state law is a copy and paste replica of the central legislation except for certain provisions which are inconsistent with RERA and covers the field which is occupied by the central enactment. The subjects of both sets of legislature are contained in entries 6 and 7 of the concurrent list.